The right to privacy was enshrined in Article 6 of the Mexican Constitution in 2009 and set the foundation for a more comprehensive data protection law in the country. The federal law on the protection of personal data held by private parties, which entered into force on the 5th of July 2010. Several additional regulations, guidelines, and international protocols have also been established, contributing to the creation of the current comprehensive privacy protection regime in Mexico. Of these, the most notable are the regulations to the Federal Data Protection Law and the Guidelines on Privacy Notices, issued by the National Institute for Access to Information and Protection of Personal Data, or INAI. INAI is the supervisory authority in charge of enforcing data protection legislation in Mexico and was established in 2014 when the Mexican Congress approved an amendment to the Constitution. INAI has the power to, among other things, issue opinions and recommendations and decisions. In addition, INAI has recently called upon the Mexican legislature to reform the privacy and data protection landscape of Mexico, for instance, by strengthening data subject rights and by introducing a whistleblower protection law. INAI also has the power to impose sanctions and penalties to organizations that violate the provisions of the Federal Data Protection Law. For example, INAI may issue a warning to data controllers instructing the implementation of actions requested by the data subject, or issue fines that can range from €420 to €1,300,000, depending on the seriousness of violations and the specific behavior and conduct in each case. Criminal penalties can also be imposed, including a potential 5 years of imprisonment. Organizations should also be aware that the regulation imposes an obligation on data controllers to notify data subjects of security breaches under certain circumstances. More specifically, a data subject must be notified if a breach may significantly affect their property or moral rights. Although there is no directly similar obligation for breach notifications imposed on data processors, they are legally obligated to notify the data controller of any security breaches affecting relevant data. It is also important to note that industry-specific notification requirements may apply, for example, in the financial sector. Additionally, Mexico participates in several data protection-related international agreements. The most significant of these are the Ibero-American Data Protection Network and the United States-Mexico-Canada Agreement, or RIPD, and USMCA respectively. The updated USMCA contains provisions that formally recognize the validity of the Asia-Pacific Economic Cooperation Cross-Border Privacy Rules, which establishes a cross-border data transfer mechanism for participating economies. Mexico is also a signatory of Convention 108, which seeks to enable cross-border flows of personal data. More recently, a bill was introduced to the Mexico Senate which would modify many of the current requirements within the jurisdiction. In particular, the bill would impose an obligation for data controllers to immediately notify INAI of breaches involving personal data and create a robust framework for dealing with cyber attacks. Organizations should be mindful that further bills to amend the existing data protection law are expected in the near future. To continue researching key compliance requirements in Mexico, use jurisdiction dashboards to quickly access the latest regulatory developments and best practice from leading experts.